Hello and welcome back to another episode of Courts This Week, your go-to source for the latest legal updates presented by Livelaw. I'm your host Syed Amir Hussain and I'm here to take you through the most significant updates from the week. From the corridors of the Supreme Court to local judicial proceedings, I'll be providing you with clear and concise summaries that keep you informed and ahead of the curve. Remember, for a more in-depth understanding, do visit our website at www.livelaw.in. In today's episode, we cover the validity of Section 6A of the Citizenship Act, the Kolkata trainee doctor rape murder case, a plea alleging COVID vaccine side effects, Abbas Ansari's bail, and much more. So let's dive into the headlines. This week, the Supreme Court delivered a significant ruling upholding the constitutional validity of Section 6A of the Citizenship Act 1955, which recognizes the Assam Accord. The decision came with a 4:1 majority from a bench that included CJI D.Y. Chandrachud and Justices A.S. Bopanna, M.M. Sundaresh, J.B. Pardewala and Manoj Misra. The Assam Accord was a pivotal agreement signed in 1985 to address the issue of illegal migration from Bangladesh into Assam. Section 6A, incorporated into the Citizenship Act as part of this agreement, allows migrants of Indian origin who entered Assam between January 1, 1966 and March 25, 1971 to apply for citizenship. However, it mandates the detection and deportation of those who arrived after this period. This provision had faced challenges from certain indigenous groups in Assam who argued that it legalized illegal infiltration of foreign migrants from Bangladesh and discriminated against the region by establishing distinct cutoff dates for regularizing illegal migrants in Assam, unlike the rest of India. The bench ruled that the Assam Accord was a necessary political and legislative solution to the migration crisis, balancing humanitarian considerations with the need to protect the local population. They highlighted the unique situation of Assam, where the impact of migration is more severe despite a smaller number of migrants than in neighboring West Bengal, owing to the smaller land area in Assam than in West Bengal. The majority opinion concluded that it was reasonable to treat Assam differently from other states with larger borders with Bangladesh because the percentage of immigrants in Assam's population was higher. The Chief Justice notably observed in his judgment that the mere presence of different ethnic groups in a state does not mean that the fundamental right to protect linguistic and cultural heritage as per Article 29, Clause 1 of the Constitution has been infringed. The majority judgment also considered March 25, 1971 as a rational cutoff date, corresponding with the end of the Bangladesh Liberation War. However, Justice Pardewala dissented, holding that Section 6A should be declared unconstitutional with prospective effect. For further details, you can read the judgment on www.livelaw.in. This week, the Supreme Court took stock of the progress in the investigation into the brutal rape and murder of a trainee doctor at Kolkata's R.G. Kar Medical College. The matter, which was taken up suo motu, was heard by a bench comprising CJI D.Y. Chandrachud and Justices J.B. Pardewala and Manoj Misra. The Central Bureau of Investigation, or the CBI, informed the court that it has filed a charge sheet against the lone accused, Sanjay Roy, for rape and murder. The additional Chief Judicial Magistrate has already taken cognizance of this charge sheet, with the next hearing scheduled for November 4th to address the charges. The CBI status report also mentioned that the investigation is ongoing into other potential suspects and a separate inquiry into alleged financial irregularities at the hospital. The bench directed the CBI to provide further updates within 3 weeks. The court also directed the state of West Bengal to disclose information regarding its recruitment process for civic volunteers, expressing its concerns over possible political patronage given to unverified civic volunteers. Additionally, the court criticized the National Task Force or the NTF set up to enhance security for medical professionals for its lack of progress. The Solicitor General informed the bench that the NTF had received over 17,000 suggestions and 7,000 responses from medical establishments. However, the court expressed dismay that the NTF had not held any meeting after September 9th and had not made substantial progress. It has directed that the task force should hold regular meetings and complete its task within a period of 3 weeks. In a crucial legal development this week, the Supreme Court decided to recall its 2022 judgment in Union of India versus Ganpati Dealcom Private Limited. The previous judgment had struck down Sections 3, Clause 2 and 5 of the Benami Transactions Prohibition Act 1988, deeming them unconstitutional. This recall comes after a review petition filed by the Union government. A bench led by CJI DY Chandrachud alongside Justices JB Pardiwala and Manoj Misra took the decision to allow a fresh hearing on the matter. The bench pointed out that during the original proceedings, the constitutionality of the provisions of the unamended Benami Transactions Act had not been explicitly challenged. Instead, the central issue was whether the 2016 amendments to the Act had retrospective application. Despite this, the earlier bench had invalidated the provisions of the unamended Act, leading to this review and recall. The bench has now restored the civil appeal for a fresh hearing, reopening the debate on the scope and applicability of the Benami Transactions Prohibition Act 1988. This week, the Supreme Court dismissed a PIL or a public interest litigation that raised concerns about health side effects from COVID-19 vaccines. The petitioners argued that the vaccines could lead to issues like blood clotting, citing similar class action suits in countries like the United Kingdom. However, the bench led by CJI Chandrachud rejected the plea, emphasizing the critical role vaccines played in overcoming the pandemic. The Chief Justice remarked that such petitions were inappropriate at this stage and suggested that genuine grievances should be pursued through class action suits rather than filing under Article 32 of the Constitution. Justice Pardiwala queried if the petitioners themselves had experienced any side effects, to which they responded negatively. The court ultimately decided not to entertain the petition further. It's worth mentioning that British pharmaceutical company AstraZeneca is currently facing legal action in the UK for alleged fatalities and injuries linked to its vaccine Covishield, which was produced in India by the Serum Institute. This week, the Supreme Court took strong action concerning the illegal tree felling of about 1,100 trees in Delhi's Rich Forest. The court directed the Lieutenant Governor of Delhi, V.K. Saxena, in his personal capacity as the chairperson of the Delhi Development Authority, to submit a personal affidavit detailing various aspects of the tree cutting incident. The bench, led by CJI DY Chandrachud and Justices JB Pardiwala and Manoj Misra, issued these directions in a contempt case against the Vice Chairman of the DDA. The bench emphasized that the affidavit must provide a complete disclosure based on both records and the LG's personal knowledge of what transpired during the site visit on February 3rd, when the LG ordered the expedited road widening project that led to the tree felling. Furthermore, the court insisted on explanations regarding the disposal of the felled timber and its inventory records. The bench also directed that the LG ensure accountability for the officials involved, recommending disciplinary action or even criminal prosecution where necessary. The court found existing records to be ambiguous and sought these clarifications ahead of the next hearing scheduled for October 22nd. This week, the Supreme Court declined to entertain a petition challenging the Jammu and Kashmir Lieutenant Governor's proposal to nominate 5 members to the J&K Assembly. According to the J&K Reorganization Act of 2019, there are 90 seats for Jammu and Kashmir divisions, while 5 seats can be filled by the LG's nominations. Recently, the NC Congress Alliance secured 48 seats in the elections to these 90 seats. Senior advocate Dr. Abhishek Manu Singhvi, representing the petitioner Ravindra Kumar Sharma, argued that increasing the number of nominated seats beyond the 90 elected members could disrupt the balance of power. He emphasized that the alliance's current majority could be undermined if additional nominees shifted the number, potentially overriding the electoral mandate. He further warned that future amendments increasing the nominations to 10 could further dilute this balance. The bench, led by Justices Sanjeev Khanna and Sanjay Kumar, pointed out that the nomination power had not been exercised yet and advised the petitioner to first approach the High Court. They made it clear that they would not comment on the case's merits at this stage. The Supreme Court this week expressed its disappointment over the failure of the Punjab and Haryana state governments in taking adequate action against farmers engaging in stubble burning, a significant contributor to the worsening air quality in the Delhi NCR region. The bench, comprising Justices Abhay S. Oak, Ehsanuddin Amanullah and Augustine George Massey, summoned the chief secretaries of both the states to appear before the court in the next hearing. The court highlighted that despite directives issued by the CAQM or the Commission for Air Quality Management in June 2021, neither state had implemented the measures, with Haryana failing to take a single penal action as required under Clause 14 of the Commission's directions. It also questioned the qualifications of the CAQM members, with Additional Solicitor General Aishwarya Bhati defending the Commission's expertise. The bench suggested engaging with a specialized agency to address the pressing issue of air pollution in the region. The court emphasized that the authorities must hold accountable those officials responsible for non-compliance and ensure immediate action. The next hearing in the matter is set for October 23rd. In a significant development this week, the Supreme Court granted bail to Uttar Pradesh MLA Abbas Ansari in a case involving allegations of unauthorized meetings with his wife while in Chitrakoot jail and using her mobile phone to threaten witnesses and officials. The bench, comprising Justices Suryakant and Ujjal Bhuyan, considered the completion of the investigation and Ansari's extended custody of over 1.5 years while deciding to grant bail. The court, however, stressed that Ansari must cooperate fully with the trial proceedings. The state's counsel pointed out that Ansari's wife had been caught carrying 2 mobile phones into the jail, which he allegedly used for the threats, and requested a direction for them to reveal the device's passcodes as the forensic team faced difficulties accessing the data. The bench directed Ansari to comply as per legal requirements. Meanwhile, another bench of Justices M.M. Sundaresh and Pankaj Mittal granted him bail in an unrelated money laundering case, noting the time spent in custody and the pending duration for trial conclusion, without commenting on the allegations. The Enforcement Directorate has accused Ansari of using 2 firms for laundering money, with Vikas Construction allegedly being the primary conduit for the offences. This week, the Supreme Court emphasized the right of sick and infirm individuals to be granted bail even under the strict provisions of the Prevention of Money Laundering Act, or the PMLA. The bench, led by Chief Justice D.Y. Chandrachud, granted interim bail to Amar Sadhuram Mulchandani, the former chairperson of Seva Vikas Cooperative Bank, who is accused of money laundering. Senior advocate Mukul Rohgi, representing Mulchandani, highlighted his client's chronic kidney disease and inability to perform daily activities while in custody. Mulchandani, aged 67, has been imprisoned for over a year without being named in any predicate offences. Opposing the bail, senior advocate Atma Ram Nadkarni argued that Mulchandani faced other charges, including evidence tampering, and suggested hospital admission under custody instead. After reviewing medical reports from a 4-member expert committee of JJ Group of Hospitals, the court decided to grant interim bail, stressing that even though PMLA is stringent, the legal provisions must be adhered to. The CJI explained that Section 45 of the PMLA allows bail for those who are sick or infirm, irrespective of the twin conditions for bail specified under the Act. This week, the Delhi High Court directed the removal of a Wikipedia page discussing a pending defamation suit filed by news agency Asian News International or ANI against the Wikimedia Foundation. The defamation case involves claims that Wikipedia published content that harmed ANI's reputation, leading to a demand for the removal of defamatory material and rupees 2 crores in damages. Earlier, the High Court had ordered Wikipedia to provide details of 3 editors who made changes to the page, but ANI alleged that Wikipedia did not comply. A division bench comprising Chief Justice Manmohan and Justice Tushar Rao Gadela observed that the page contained adverse comments against the single judge hearing the case, which they deemed prima facie contemptuous. The page reportedly stated that the judge had threatened to direct the government to shut down Wikipedia in India. The court took issue with this description and directed Wikipedia to remove the page and related discussions within 36 hours. During the hearing, senior advocate Akhil Sibbal, representing Wikipedia, clarified that the edits in question were not directly created by Wikipedia, but assured compliance with the court's order if directed. The matter will come up for further hearing next week. And that's a wrap for this week's Legal News Roundup. Before we bid adieu, the entire Livelaw team has a small request for our dedicated viewers. As an independent and fact-driven media organization, we are deeply committed to fearless and ethical journalism. To continue bringing you the latest legal updates, especially in this dynamic audiovisual format, we rely on your support. Here's how you can help. Give our video a thumbs up if you found it informative. Share it with your family, friends, classmates, and colleagues. Make sure you're subscribed to our YouTube channel for more insightful content. Drop your valuable thoughts and feedback in the comments section below. And hit that bell icon to stay updated with our latest releases. Don't forget to visit our website at www.livelaw.in for in-depth reports and analysis. Not only this, but the Livelaw channel offers memberships for only ₹89 a month. Become a part of LL supporters today to access exclusive perks such as loyalty badges next to your name in comments and live chat, priority reply to comments, and for our student pass audience, early access to explainers and legal updates. I'm your host, Syed Amir Hussain, and it's been a pleasure bringing you this week's Legal News Roundup. Until next time, stay informed, stay engaged, and stay tuned to Livelaw. Thank you for watching.